Good afternoon and welcome to McLean Middleton's webinar, Are You Ready for Paid Family and Medical Leave? What every Massachusetts employer needs to know now. My name is Adam Hamel. I'm a director in the litigation department at McLean Middleton and also the vice chair of the employment law practice group. With me is my colleague.
Geiger, I'm the law practice as well, and a member of the litigation department.
We want to thank everyone for joining us today. We're going to be talking with you for the next hour about the new paid family and medical leave law in Massachusetts. We're going to be going through and giving an overview of the law and then delve into some of the technical details of the law. Before we really get started, I just wanted to make a few sort of initial points and to sort of remind everyone that this is really a fluid situation. Things are continuing to change with this law almost on a day-to-day basis. The regulations that we currently have are still in draft form. They could change between now and the implementation date of July 1st. Also, it's important to know that there is an effort underway being led by the Associated Industries of Massachusetts and supported by other groups to seek to have the implementation postponed by 3 months. As I mentioned, there is some pretty broad-based support for this effort, but we're not sure what the legislatures and the governor are going to do about that. So really, the best advice is to, continue checking the Department of Family and Medical Leave website as we get closer to July 1st. Sign up for our mailing list. We'll keep you as informed as we can. Also, the Associated Industries of Massachusetts has a email mailing list on this topic. So there are resources out there, but between now and July 1st, you want to sort of keep your ear to the ground and watch what develops. So really, though, as we know that the full implementation of this law, people receiving benefits, won't begin until 2021. So really, the focus for employers at this point should be on 3 things. That is meeting the notification requirements that go into effect at the end of this month, taking care of getting ready for making your contributions to the trust fund, and then thirdly, considering whether or not as an employer you should seek to get an exemption for a private plan. And we'll spend some time talking about those topics today. So in general, the paid family and medical leave law, sort of as a broad overview, is this law was enacted as part of what was called the Grand Bargain, signed into law by Governor Baker on June 28th, 2018, addressed a number of issues that were on that would have been ballot questions. And so, as you probably know, that employees will begin making contributions to the trust fund beginning on July 1st. Most of the benefits will be available to employees beginning on January 1st, 2021, and then there's some other benefits that don't actually go into effect until July 1st of 2021. So the broad overview of the law is that it provides eligible employees with up to 12 weeks of paid family leave and up to 20 weeks of paid medical leave with a combined maximum of 26 weeks, with a guarantee that they can return to work at the same pay, status, and benefits after the leave is over. The benefits will be paid from a newly created Family Employment Security Trust Fund, which will be funded through a new payroll tax. That payroll tax is going into effect at the end of this month. I'm going to turn it over to Alexandra, who's going to talk about who is covered by this law.
So good afternoon. I was told that you all couldn't hear me before when I introduced myself because I wasn't talking directly into the microphone. I'm Allie Geiger. I am an attorney in the employment law practice group here at McLean Middleton. I'm also a member of the litigation department. So I'm going to talk about who is covered by this law. So first, we have all Massachusetts employers regardless of size. And the statute here uses the same definition as Chapter 151A, which is the Massachusetts Unemployment Insurance Statute. And it's important to note that individual employers will be determined by their federal employer identification number. And this is going to become relevant when you start to calculate your workforce, which Adam will talk about a little bit later. All Massachusetts W-2 employees are covered by the law. This includes full-time, part-time, and seasonal employees who meet the financial eligibility requirements. And it's important that there is no minimum length of service or hours worked required in order to be eligible for the benefits. This is, of course, different than some other leave laws like the FMLA, which requires 12 months of service and a certain number of hours during your prior 12 months of work. Interestingly, this law also covers former W-2 employees who have met the financial eligibility test at the time they're separated from their employer, if the separation has not been more than 26 weeks. So this is unlike any other leave law in that it protects former employees. In addition to Massachusetts employers, you might be a Massachusetts employer, or you might be a covered business entity under the law. And the regulations define a covered business entity as a business or trade that contracts with self-employed individuals for services and is required to report the payment for those services on 1099 forms for more than 50% of its workforce. So if you're a company whose workforce is made up of more than 50% 1099 workers, you are going to be covered under this law. And likewise, covered contract workers, those are those 1099 workers who work for a covered business entity with more than 50% 1099 workers. The law also covers self-employed individuals. So those are sole proprietors, members of LLCs or LLPs, or anyone who lives in Massachusetts and whose net profit or loss is required to be reported to the Department of Revenue. Municipalities, towns, districts, and political subdivisions are not covered under the law unless they choose to opt in by majority vote of the local legislative or governing body. Okay, so where it gets tricky is if you have a multi-state employer, or if you're a company that's based in another state but you have employees that perform work in Massachusetts, or you're a Massachusetts company with employees that perform work in other states. Who is covered in those circumstances? The regulations talk about a term called localized in MA, in Massachusetts, and they say that an employer covered business entity and an individual are covered if the service the individual performs is localized in Massachusetts. So what does that mean? That means that the service is performed entirely within Massachusetts, or the service is performed both within and outside of Massachusetts, but the service performed outside Massachusetts is incidental to the service within Massachusetts. So here you could be a New Hampshire or Rhode Island employer and still be subject to the law if your employees are performing services that are localized in Massachusetts. So to make things even trickier, there's another category of covered individuals and employers where the service is not localized in any state. And to be covered in that circumstance, some part of the service has to be performed in Massachusetts, and the individual's base of operations is in Massachusetts, or if there is no base of operations, the place from which the service is directed is in Massachusetts. Or, so then the second part of this, not localized in any state, where some part of the service an employee or covered individual performs is in Massachusetts, and the individual's base of operations or place from which such service is controlled is not in any state in which some part of the service is performed, but the individual resides in Massachusetts. So I know that's confusing. So we're going to go over a couple scenarios here that I hope will illustrate how this works. So scenario one, Jane delivers goods for her employer to businesses in Massachusetts. Occasionally, Jane also delivers goods to businesses in Rhode Island and New Hampshire. Jane is covered under the paid family and medical leave law because the services she performs outside of Massachusetts are incidental to the services she performs inside Massachusetts. And I'm going to note here that it really doesn't matter where Jane's employer is located because her services are localized in Massachusetts. Scenario two, Tom lives in Rhode Island but works in Boston for a Massachusetts company. Tom is covered under the paid family and medical leave law because his services are performed entirely within Massachusetts. Scenario three, Stacy lives in Massachusetts and works remotely for a New Hampshire company. All of her work is directed by her employer's headquarters in New Hampshire. Stacy is covered under the paid family and medical leave law because the services she performs are in Massachusetts and she lives in Massachusetts. Scenario 4. Rick's employer is headquartered in Massachusetts, but his assigned sales territory is the Pacific Northwest, where he spends most of his time. He receives instruction from the Massachusetts office and sometimes attends meetings there. Rick is covered under the paid family and medical leave law because the base of operations is in Massachusetts and Rick performs some services in Massachusetts. Again, here it doesn't matter where Rick lives. So if you have individuals, workers, whether they're 1099 or employees, and you might be an out-of-state company, or whether you have employees that work partly in other states and it's not clear if the services they provide are localized in Massachusetts, you really need to go through this analysis.
So now I'm going to talk a little bit about the benefits that are provided for employees under the law. But before I do that, I recalled that I forgot to mention at the outset that we are going to try, if we have time, to answer some questions that may come up if we have some time at the end of the webinar. So if you have a question that you'd like us to answer, on your screen somewhere you should see a Q&A button. If you press that button, you should be able to enter a question. We'll collect those questions and review them, and if we have the ability to, at the end of the webinar, we'll answer some of those questions. So in terms of the benefits and the leave that is provided for employees under this law, so beginning on January 1st, 2021, covered individuals can take up to 20 weeks of medical leave for their own serious health condition. Now, the law and the regulations define a serious health condition as an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical facility, or continuing treatment by a healthcare provider. Now, continuing treatment by a healthcare provider is further defined by the regulations as several different things, including incapacity and treatment, pregnancy and prenatal care, chronic conditions, permanent and long-term conditions, and conditions requiring multiple treatments. That first subset there, incapacity and treatment, that involves an inability to work for more than 3 consecutive calendar days and receiving treatment from a medical care provider under specific requirements that are set out in the regulations. In addition to that, or it's worth noting that cosmetic treatments are not covered as serious health conditions unless there is inpatient hospital care or there's complications that develop in connection with those cosmetic treatments. In terms of the family leave benefits that are available, beginning on January 1st, 2021, covered individuals can take up to 12 weeks to bond with a child during the first months after the child's birth, adoption, or foster care placement. Also beginning January 1st, 2021, covered individuals can take up to 26 weeks to care for a family member who is a covered service member. Up to 12 weeks for a qualifying exigency arising out of the fact that a family member is on active duty or has been notified of an impending call or order to active duty in the armed forces. And then this last category of family leave, this one doesn't kick in until July of 2021, and that is covered individuals can take up to 12 weeks to care for a family member who has a serious health condition. In terms of the leave allotments, what it is that people are able to use. And so there is as we mentioned, there's, the different time periods for family and medical leave is that regardless of how that gets used, any covered individual is limited or capped at a total aggregate allotment of 26 weeks of paid family and medical leave during the benefit year. Now, the benefit year is defined by the statute and the regulations as the 52 consecutive weeks beginning on the Sunday immediately preceding the first day that the job protected leave commences. So in other words, that 52-week period runs basically from the time that an employee starts using the benefits to 1 year after that. And that's the period we're looking at for this 26-week total aggregate allotment. Leave allotments are based on the number of hours or days a covered individual works. So if you have a part-time employee, their leave allotment is prorated. Leave allotments for employees who have variable schedules are determined based upon their weekly average hours for the 12 months preceding the leave. So for example, if you have a part-time waiter who has a schedule that varies from week to week, that employee's leave allotment would be calculated by taking the average weekly hours that that employee is scheduled for the previous 12 months. So even if he works, one shift 1 week and 4 shifts another week and 3 shifts another week, you would to determine the amount of allotment that that person has, you would go back 12 months and figure out what the average weekly scheduled hours is. The law allows employees, covered individuals, to take intermittent leave under certain circumstances. So for instance, with regard to leave taken for bonding during the 12 months after a child's birth, adoption, or foster care placement, intermittent or reduced schedule leave is only permitted if both the employer and the employee mutually agree to the intermittent leave. With regard to care for a family member, intermittent or reduced schedule leave is only permitted if the healthcare provider to the family member determines that such intermittent leave is medically necessary. With regard to an employee or a covered individual's own serious health condition, intermittent or reduced schedule leave is permitted if it is medically necessary. And the law and the regulations talk about how an individual and an employer must attempt to work out a leave schedule that meets the individual's need without unduly disrupting the employer's operations, subject to the approval of the healthcare provider. This raises some questions, and unfortunately, as is the case with some of the things in this law, there aren't always clear answers to these questions. But the questions that arise here is, what happens if an employer and employee can't agree, or if there's a dispute about what is unduly disruptive to the employer's operation? More guidance is needed on these subjects, and we're hopeful that between now and when this actually comes into effect in 2021, that we'll get some more guidance as to how this will get dealt with, because the intermittent leave is clearly something that is of concern to employers. With regard to further regard to intermittent leave, an employee who is on intermittent or reduced leave schedule who fails to work during the times that or on the schedule that's agreed to can be subject to discipline. So for instance, if you have an employee with whom you've agreed or you have an arrangement that they will have intermittent leave that allows them to be out for 1 day a week, or if reduction in their hours, if they're not meeting the times that they are supposed to work, that is something that is potentially subject to discipline by the employer. And also the regulations state that the employer should report that failure to the Department of Family and Medical Leave. Now, intermittent leave, how does that work with the leave allotments for employees? So what will happen is that intermittent leave will result in a proportionate reduction in the total available allotment of leave. So as a scenario there, you have an employee named Mike who normally works 40 hours a week, and he takes 8 hours of intermittent leave in a week. That leave is going to count as 1/5 of 1 week of leave allotment. So, of his, 20 weeks of medical leave, for that 1 8-hour time of leave, that only counts as 1/5 of 1 week. Similarly, in scenario 2, we've got, an employee named Janice who normally works, she's part-time, works a 30-hour week, and she, as a result of her taking advantage of the benefits of the law, is now taking a 20-hour reduced schedule leave. And so that 10-hour reduction in her normal work schedule counts as a 1/3 of 1 week's of her leave allotment. So, and then also, we'll get to this in a minute too, a little bit more about how the benefits that are being paid to individuals on intermittent leave are prorated based on the amount of leave that they're taking. So claims for benefits, talked a little bit about how the claims process is going to work. So of course, since these benefits won't actually be available for another 18 months until 2021, the logistics of the benefit claim, so for instance, the forms, the instructions, the procedures, etc. of that process, they're still being worked out, but the draft regulations do provide some insight as to how this is going to work. Employees will be required to give both the Department of Family Medical Leave and their employer at least 30 days notice before a planned family or medical leave, unless reasons beyond the employee's control prevent advance notice. And so generally, in most circumstances, people are going to know in advance that they're going to have a baby or if they're going to have a knee replacement or something like that. In those circumstances, the employee is going to have to provide notice both to the department and to their employer that they're going to be taking leave. However, sometimes advance notice is not going to be possible. For instance, if there's an injury that arises from an accident or some sort of a surprise diagnosis. In those instances, the regulations provide that notice in the claims process will just simply need to be done sort of as soon as is reasonably possible. Employees will be required to provide a certification justifying a leave. Depending upon the type of leave, that certification may be required to be from a healthcare provider, and the regulations provide some guidance or some specifications about exactly what is supposed to be included in that certification in terms of the type of leave that's being taken, the type of the medical condition, the amount of leave, the duration of the leave that is expected, and things like that. Now, also, employers will need to provide information to the Department of Family and Medical Leave in connection with a claim for benefits. And that information that the employer will need to provide includes information about the employee's wages, the hours that they work, other requests for leave that the employee has made, as well as information about the employer's paid leave policies and whether or not the employee has received benefits under those policies during the current benefit year, because that may affect the employee's eligibility or the amount of benefits that they will receive. In terms of the benefit payments themselves, those payments will be calculated based on the employee's average weekly wage. Now, the benefit payment is going to consist of 80% of the employee's average weekly wage that is less than or equal to 50% of the state average weekly wage, and then over and above that, 50% of the employee's average weekly wage, which is more than 50% of the state average, up to the maximum set by the Department of Family and Medical Leave each year. So in the first year, in 2021, that maximum has already been set at $850 per week. So under no circumstances is any employee or covered individual going to receive benefits in excess of $850 per week in the first year. However, in subsequent years thereafter, the department is going to set a new maximum each year, and that will be based at 64% of the then applicable state average weekly wage. Employees who are on intermittent or reduced leave schedule will have their benefit payments reduced in direct proportion to their leave, as I mentioned. So going back to the two scenarios we talked about before, those two employees, so Mike, our employee who is working 40 hours per week and taking 8 hours as intermittent leave, his benefit payment for that week will only be 1/5 of what he would be receiving otherwise if he were taking a full week of leave under the law. And similarly, with regard to the other employee we discussed, Janice, who was a 30-hour per week employee on a 20-hour per week reduced leave schedule, she again would be receiving 1/3 of the benefit payment that she would have been receiving otherwise. Also, it is worth noting, or it's important to note, that for all claims for benefits, there is a 7-day waiting period for all employees. And so no benefits at all will be paid during the first 7 calendar days of an approved initial claim for benefits. And so these 7 days, however, will count against the total leave allotment. So in other words, the first week, essentially, of paid family or medical leave is really unpaid. However, employees during that time period, during that 7-day waiting period, still can use other paid leave available to them. For instance, any earned sick time that is available to them under the Massachusetts Earned Sick Time or any other employer-provided paid leave plan while they're waiting for their benefits to kick in. Now, moving to the next subject is what happens when an employee's leave is over, returning to work after leave. The law and the regulations talk about how an employee who returns after an approved family or medical leave must be restored to the employee's previous position or to an equivalent position with the same status, pay, employment benefits, length of service credit, and seniority as of the date of leave. A sort of caveat to that is that an employee does not need to be restored to the previous or equivalent position if, while the employee was on leave, other similarly situated employees have been laid off due to conditions that arose during the leave. However, if that happens, if you have a reduction in force while someone is on leave, that employee who is returning from leave again does not need to be put in their same position, but such an employee would need to retain any preferential consideration that they have for another position which they would have been entitled to at the time leave was taken. So really, what you do want to make sure you're doing is if you have a reduction in force while you have employees on this type of leave, you're going to want to be careful and to consult with counsel to make sure that you're doing things in the correct way and not running afoul of this. It's important to note that upon reinstatement, the taking of a leave will not affect an employee's right to accrued vacation time, sick time, bonuses, advancement, seniority, length of service credit, or other employee benefits plans or programs. However, that leave period, the time where they're gone on paid family and medical leave, is not credited as service for purposes of benefit accrual. With regard to employer-provided health insurance benefits, while the employee is on leave, the employer must still continue to provide the employer portion of those benefits. In a lot of respects, these two bullets I've just talked about is similar to other types of job-protected leave, but it's really important to be aware of that. Employers may have a uniformly applied policy for or practice for requiring all similarly situated employees to provide a certification of fitness for duty at the conclusion of medical leave. So if you would like to, the law does allow for you, when an employee returns from work, you can require a fitness of duty certification from their medical care provider. However, if you do so, it has to be part of a uniformly applied policy or practice, because otherwise you would run afoul of or have some issues with discrimination or disparate treatment. So you want to be careful of that. The next topic, and this is one that is probably of critical interest to people now as we are approaching the deadline, is the notice requirement. And so under the law and the regulations, all employers and covered business entities have to display a poster prepared for, by, or approved by the Department of Family and Medical Leave, which describes the benefits available under the law. The poster has to be displayed both in English and in any other language, which is the primary language of 5 or more covered individuals in the employer or entity's workforce. These posters are already available on the Department of Family and Medical Leave's website. If you don't already have them posted in your workplace, you'll want to go to the department's website, download the posters, and get them up right away. Also, in addition to the posting requirement, there is a requirement to provide written notification to covered individuals. So by June 30th, 2019, by the end of this month, all employers and covered business entities must provide written notice to their current workforce of the paid family and medical leave benefits, contribution rates, and other provisions. The department has template notices available on their website, and they're notices that are based on both employers as well as covered entities. And so and the form is fairly straightforward, pretty easy to fill out. So you might want to use that form to meet this requirement. The notice has to include the opportunity for an employee or a self-employed individual to acknowledge their receipt or decline to acknowledge receipt of the information. So what you'll want to do is to at least attempt to get all of your covered individuals to sign that acknowledgement on the notification and keep a copy of that. If for some reason an employee refuses to sign that, the regulations provide for what you can do in that case to document that you have provided the notice to that employee. Both the notice and the acknowledgement can be provided electronically, which may make it easier for you to comply with that. And then after that initial notification to the current workforce, after July 1st, 2019, employers and covered business entities have to give written notice to all new employees within 30 days of them starting their employment, and also must give notice to covered self-employed individuals at the time of contracting. The next, I'm going to move to the contribution piece, and that's the part also that is of critical importance or of interest to people, because it begins at the end of this month. And so the contributions to the Family and Employment Security Trust will begin on July 1st. The contributions will be made through payroll deductions at an initial rate of 0.63% of all qualified earnings, up to the base amount set by Social Security Administration. The paid family medical leave contribution rate, again currently set for the first year at 0.63%, will be set by the Department of Family and Medical Leave annually, no later than October 1st. So by the beginning of the third quarter of each year, we'll know what the contribution rate for the next year is going to be. Now, these contributions, this 0.63%, is going to be allocated differently between medical and family leave in proportions set by the department annually. Initially, in that first year, the contributions will be allocated, so 82.5% of the contributions, which translates to a 0.52% payroll deduction, will be allocated to medical leave, and then 17.5%, or which translates to the 0.11% of payroll deduction, will be allocated to medical leave. There is some cost sharing between the employer and the employees on this, and so the employer's minimum share of the medical leave portion, so that 0.52% of the payroll deduction, the employer's minimum share of that is 60%, and the employer's minimum share of the family leave portion is 0. Employers, of course, are free to pay a larger share of that if they choose to. Now, here's a visual representation of what that contribution scheme looks like. And this image comes from the Department of Paid Family and Medical Leave's website. But you can see that that total contribution is the 0.63% payroll deduction. 0.52% is allocated to medical leave, 0.11% allocated to family leave. And so the employer share is 60% of the medical leave contribution, and the employee's share is 40%. With regard to the family leave, 0% is the minimum amount that is an employer must pay, and 100% is the maximum amount that an employee is required to pay. Now, for smaller employees, however, it's a little bit different. If you have fewer than 25 covered individuals in your workforce, the employer is exempt from paying the employer's share of the medical leave portion. And what that results in is that sort of exemption from the smaller employer of paying that employer provision, that does not then mean that the entire cost is shifted to the employee. The employee still only needs to pay 40% of that themselves. And so that means that for those people, it'll be a smaller amount will be going into the trust fund. So a little bit more on that in terms of calculating your workforce for purposes of determining whether or not you fall into that smaller employee category. And so what it says that employees with an average total workforce in the Commonwealth of fewer than 25 persons are not required to pay that employer portion. Employers who are not covered business entities will determine so in other words, really just employers who don't have any of those covered self-employed people, the calculation is a little bit easier. You determine your average total workforce by counting all full-time, part-time, and seasonal employees on the payroll during each pay period, and then dividing it by the number of pay periods. For covered business entities, that means people who have at least 50% of their workforce made up by covered independent contractors. That calculation of your average total workforce is a little bit more complicated, because what you do is you take the total number of full-time, part-time, and seasonal employees on the payroll, and then add to that the number of qualified self-employed individuals, add those two together, and then divide it by the total number of pay periods. So according to the Department of Family and Medical Leave's website, this calculation or this determination of your total average workforce is done on an annual basis, an annual average. So if you are an employer that has, sort of a high seasonal rates of employees, so for instance, you run, an ice cream business, or if you're a landscaper, and so, during the summer, you can have a lot of employees, but in the wintertime, not so many, you're still going to do that calculation of your average total workforce on an annualized basis, okay? And it's worth noting that the Department of Family and Medical Leave, on their website, they have a really useful and helpful calculator to help you run different scenarios for determining, what your average total workforce is, and what your contribution rate is going to be. You can sort of toggle things and then put in different values and really kind of play with what you want to do in terms of, your voluntary allocation of that that pay between the employer portion and the employee portion. I'm going to turn it over to Allie now, who's going to talk about the private plan exemption piece.
Okay, so I know this is something most of you have probably been thinking about. We've certainly received a lot of questions about the private plan exemption option. So I'm going to go through it in detail, and we'll start with talking about the requirements, what your private plan would need to have in order to be an approved exempt plan under the law. So first, the private plan must confer all of the same benefits as those provided under the Paid Family and Medical Leave law to be exempt. But I should note that benefits do not need to be available under the private plan until benefits are available under the law in January 2021. So, for example, your private plan would need to do things like cover all of your part-time employees, your former employees if they've been separated for 26 or less weeks. I'm sure most of you don't have private plans that already do that. So when they say they must confer all of the same benefits, they truly mean all of the same benefits. The private plan may not cost employees and covered contract workers more than they would be charged under the state plan. The private plan must also provide equivalent or better rights and protections as those provided under the Paid Family and Medical Leave law. And that includes the employee shall be restored to his or her previous position or to an equivalent position, the protection from retaliation for an employee exercising his or her rights under the law, and the right to appeal if the benefits are denied. So again, all of the same or equivalent or better rights and protections must be provided. In addition, the plan must specifically state that all presumptions shall be made in favor of the availability of leave and the payment of leave benefits. If your private plan provides for insurance, the forms of the policy must be issued by a Massachusetts licensed insurance company. So we're not currently aware of any insurers that offer plans that meet the exemption requirements. And I think in part that's because insurers are waiting to see what the final regulations say in July. But we do expect that there will be some plans that will come on the market prior to 2021. We're just going to have to wait and see what happens with the regulations. Also, if your private plan is in the form of self-insurance, the employer or covered business entity must furnish a bond to the department running to Massachusetts in the required amount and form, or in the form required by the department. So the Department of Family and Medical Leave has already put forth the bond values that you would need to furnish. So it's $19,000 for a qualifying family leave plan for every 25 covered individuals, and then $51,000 for a qualifying medical leave plan, and $70,000 for a qualifying family and medical leave plan. So, and that's for each set of 25 covered individuals that you have. This information is on the department's website. I should note that the bond forms are not available yet, but they will make them available at a later date. So you can still submit your application for an exemption and then submit proof of bond coverage later on. Let's talk about how do you apply for an exemption. So you can apply for an exemption for the family leave portion of the law, medical leave, or both. You apply with the department through your account on Mass Tax Connect. The department is currently accepting applications, and the deadline for applying for an exemption for the first quarter contributions is September 20th, 2019, so you should all have that date in mind. You can certainly apply later. The applications are accepted and reviewed on a rolling basis, but they would only, once they're approved, then you would stop submitting contributions the quarter following the date of approval. The department has a really quick turnaround for these applications. They are going to make a determination as to whether or not your plan meets the exemption requirements within 1 to 2 business days. If you are approved, they're going to ask you to upload your plan. And if you have a self-insured plan, you're going to need to provide proof of bond coverage. If you're denied, if your application is denied, you will be notified as to why. You'll also be able to request a follow-up review. The department has a really helpful, it's about 4 pages, it's a list of questions that they're going to ask you if you go to apply for an exemption. And I would definitely recommend those of you who are considering it to go on the website and download that list, and you can go through point by point to make sure the plan that you're considering an application for meets all of these requirements. Okay, so probably one of the questions I've gotten the most is, I already have a short-term disability policy. Do I meet the exemption? And I think we may have already gotten one of these questions in the question box for this webinar. The answer really is no. A short-term disability plans, I've never seen one at least, do not confer all of the same benefits as those provided under the law. Again, they don't apply to former employees. There's none of the job protections that the PFML law requires. And there's no presumption in favor of the employee. They're just not going to meet the requirements for the exemption. In addition, the language and the regulation suggests that short-term disability plans are not qualifying for the exemption, that they're really supposed to be separate from any benefits that you're going to get under the law. So the regulations state that the weekly benefit amount for a period shall be reduced by the amount of wages or wage replacement that a covered individual on family or medical leave receives for that period from a permanent disability program of the employer. So unless the aggregate amount a covered individual receives exceeds her average weekly wage, the weekly benefit amount for a period shall not be reduced by the amount of wage replacement she receives for that period from a temporary disability policy or program of the employer. So what the regulations are saying is that a person can really receive both a PFML benefit as well as short-term disability, as long as it doesn't make them more than whole. So I'm going to go through a scenario here that I think will illustrate this. We have Kate, who earns $500 a week, and she's approved for, let's call it family leave benefits. Kate also goes on short-term disability, which covers 60% of her wages. The total amount of benefits Kate receives from the Department of Family and Medical Leave and short-term disability is greater than the $500 a week. That's her average weekly wage. Kate's paid family and medical leave benefits will be reduced so the aggregate amount does not exceed $500 a week. So in that case, it is not the short-term disability benefits that will be reduced, it's the paid family and medical leave benefits, so that Kate is not made more than whole. And as far as we can tell, the employer is not going to receive any kind of credit for that because essentially their short-term disability policy will be covering a portion of the benefits that Kate would have received under the law. You can imagine a situation where you have a higher earning employee who could receive the full short-term disability benefits and paid family and leave benefits because combined their total would not exceed their average weekly wage. So I think we can expect, with the short-term disability policies, I think we can expect to see, short-term disability wraparound plans be fashioned so that we don't have a situation like Kate's where an employer is essentially, the short-term disability is greater than, puts the employer over that $500 a week for Kate average weekly wage threshold. So keep an eye out for those plans. Okay. How is the department going to make sure that an employer who has been approved for an exemption continues to meet the requirements? The regulations allow the department to audit private plans. They don't explain the audit process. They just say that they're allowed to do it. They also say that the department may require periodic reporting for private plans to ensure compliance. The department may withdraw approval for a plan when terms or conditions change or have been violated. For example, if you fail to pay benefits or if you fail to submit reports, the required reports to the department. So an employer or covered business entity that fails to maintain a private plan as approved by the department may be assessed a penalty of up to 0.63% of its total payroll for the period it failed to maintain the plan, and may be required to repay the trust fund the total amount of benefits paid to covered individuals under the trust fund. So that is a hefty penalty, especially for a larger employer, 0.63% of its total payroll, if you fail to maintain your plan in accordance with the requirements under the law. In addition, an employee has a right to bring suit in superior court against an employer for retaliation due to the employee exercising his or her rights under the law. And the employee will have 3 years to do that within the time the violation had occurred. And the remedies, again, they're steep. They include reinstatement, treble damages for any lost wages or benefits, cost, and attorney's fees. So those remedies are similar to the ones available under the Massachusetts Wage Act. So we've also gotten a lot of questions about how this law interacts with other leave laws and paid leave policies from an employer. So the regulations say that leave taken under the paid family and medical leave law runs concurrently with leave taken under other leave laws. For example, the Massachusetts Earned Sick Time Act, which we know gives 40 hours of sick time, up to 40 hours of sick time per year, and applies to all private employers. If you have an employer with 11 or more employees, that has to be paid. If you have less than 11, then it does not. In addition, the Massachusetts Parental Leave Act, which provides 8 weeks of unpaid parental leave per child. So if you have twins, it's double that. And that applies to employers with 6 or more employees. It also runs concurrently with the FMLA, which of course provides 12 weeks of unpaid leave and applies to employers with 50 or more employees within a 75-mile radius. So it's important to note that all of these laws, they have different eligibility requirements than the paid family and medical leave law. You might be subject to only one of them, to all of them, but you need to consider them when you are dealing with the leave issues under the new paid family leave law. So what about employer-provided paid leave? So employees or covered individuals with the need for leave for a qualifying reason may choose to use accrued paid leave provided by an employer rather than applied for paid family or medical leave benefits. Employers cannot compel employees to first exhaust their PTO prior to taking leave under the paid family and medical leave law. So employers or covered individuals who choose to use accrued paid leave must follow the employer's notice and certification processes. In addition, employers must inform their employees who choose to use accrued paid leave that it will run concurrently with the paid family and medical leave period. So again, like the leave laws, any employer-provided paid leave is going to be run concurrently with any leave under the Paid Family and Medical Leave Act. So importantly, employees may not be compensated with paid family and medical leave benefits for a period of time for which they received accrued paid leave from their employer. So unfortunately, the current regulations do not allow an employer to supplement leave benefits under the paid family and medical leave law with their leave policy. So that's different than how the short-term disability benefits work, where you can receive both. Here, an employee can't receive both, or an employer cannot supplement those benefits to make an employee whole. I note again here that the regulations are in draft form, so this could change, but right now this is the status of the regulations. So just by way of example here to illustrate that point, let's say you're an employer and you have a 4-week parental leave policy that pays 100% of an employee's salary. Your employee takes 4 weeks, the full 4 weeks under that policy. After that employee takes those 4 paid weeks of leave, they're only entitled to 8 weeks of paid family and medical leave benefits under this law, not 12 weeks, because the employer's leave policy runs concurrently with the paid leave benefit period. So to wrap up, here is this diagram we got from the Department Medical Leave website. It shows the key dates that you need to be thinking about now. I note that the notice deadline, the June 30th notice deadline, is not on here, and the September 20th deadline for applying for that first quarter exemption is not on here. But I'll note that, so we have July 1st, we should see the final regulations. So we will definitely be waiting for them, and we will be updating. We'll probably send a blog post about that as soon as they come in. October 31st, 2019, that's when the contributions are due for that first quarter benefits. And then on January 1st, 2021, that's when the benefits are going to start to become available to employees. So you have some time to figure out how the claim process works and all of that. Right now, we really think you should be focusing on the notice to the employees, calculating your workforce, and then thinking about whether or not you're going to consider a private plan exemption. So I'll turn it back over to you. And I think we have questions.
So yeah, we have a little bit of time left for questions. We've got a lot of questions from folks, and we appreciate those. And so we'll try our best to answer a couple of them as best we can. One of the first questions that we received is, will the payroll deductions be pre or post tax? And the answer to this question is there is no answer to this question. According to the Department of Family and Medical Leave's website, the department has requested and is awaiting guidance from the Internal Revenue Service with regard to how these are going to be handled. At least as far as we know, based on what's on the website now, is that guidance has not been provided yet from the federal government. However, what the department is suggesting on the website is that they're predicting that the deductions are going to be post-tax. But again, keep your eye on the website and figure out and see what's happening there. Another question was sort of just a clarification of something that I had said before, is that, it talks about the total allotment of time at 26 weeks. And so the question was, the cap is 26 weeks. Is it really 25 weeks of paid through the trust fund and then 1 week unpaid? And that sort of is, I guess, a way that you could look at it, because when you could take into consideration that 7-day waiting period before benefits actually get paid, so that, that at a maximum, an employee might be able to take a total combined family and medical leave of up to 26 weeks, but that's right, that they would actually only receive pay from the trust fund for 25 of those weeks, because they would not receive any benefits from the trust fund during that first week. However, as I mentioned, if they have other paid leave available to them, such as under the Mass Earned Sick Time Law, and if it's applicable, they might be able to receive that for that first week. Then the last question before I turn it over to Allie is with regard to the payment of the employee portion of employer-provided health insurance while an employee is on leave. As I mentioned, that while employees on leave, the employer will continue to have to pay the employer portion of that employer-provided health insurance. What happens with regard to the employee portion? And the regulations state that the employee portion of the employee's employment-related health insurance benefits shall be remitted by the employee in accordance with the employer's uniformly applied policies and practices. So really, this is the same as what happens when you have an employee who's on FMLA leave. During that leave, you'll continue to pay the employer portion of their health insurance benefits, and essentially they need to send you a check for the employee portion of that. So if you don't already have one, you probably should have a policy or practice in place for dealing with that circumstance. I'm going to turn it over to Allie to answer a couple of questions.
Okay, so we've gotten some questions about which employees are covered under the law when you've got, employees located in different states, employers in different states. The first is, if an employee lives in Massachusetts but works in New Hampshire, are they covered? I'm assuming here that the employee works exclusively in New Hampshire, and therefore those services the employee performs are localized in New Hampshire. So I would say the answer is no. But again, if that's not the case, we would probably need to do a further analysis. What if an S Corp in Massachusetts, there's one employee who works in Massachusetts but resides in New Hampshire? So here, there's no, all Massachusetts employers are covered by the law. I'm assuming this employee's services are performed exclusively in Massachusetts, or at least predominantly in Massachusetts. So I would say yes, this employee is most likely covered under the law because their services are localized in Massachusetts. What if you have an employee that lives in Massachusetts, works for a New Hampshire company in New Hampshire, but occasionally works from home in Massachusetts? Okay, so here it sounds like the employee services would be localized in New Hampshire because they only occasionally work from home. I would say probably not. But if this is a situation where the employee works from home a lot, then I think that you need to think about, you need to do further analysis. But I'd say probably not in that situation. Sorry, we have a lot of questions here. Okay, so here's one that has to do with the coordination of other leave laws. Can this leave run at the same time as FMLA? The answer is yes. I will make a note about the FMLA, not to confuse everyone more, but the benefit year, the definition of a benefit year under the paid family medical leave law, I believe it starts the Sunday before benefits are taken. Whereas in the FMLA, I believe employer has some discretion to decide what the calendar year there is, or what the benefit year is going to be under the FMLA. And oftentimes people use, the calendar, the January 1 to December 31st calendar year. So you just need to keep in mind if your FMLA policy designates a different benefit year, you're going to need to think about that when you have employees taking leave under the paid family medical leave law.
So we've had a couple of questions or requests for copies of the slide presentation, and we will make that available to the participants by email after the event is over. So we did have several other questions that we weren't able to get to. We'll take a look at those questions, and maybe we'll, if we can, put together some sort of a follow-up email that we'll send out to people with regard to those. And so lastly, I just wanted to mention, this is sort of the typical disclaimer that you get from attorneys at these kinds of presentations, is that, that this presentation is not legal advice. It's really intended as an educational opportunity to kind of make you aware of some of the provisions of the law and provide some background information. And that's really particularly important in this case because this is a complex law. It's a law that's changing a lot, and how it will be implemented in your organization going to depend upon the specific facts that you have. So continue to study this and consult with your employment counsel about your specific situations before you take any action with regard to this. So again, be on the lookout for further information as things continue to change over the next couple of weeks, and we'll do our best to try to keep you notified. And at the end of the day, we'll all get through this, and we'll be able to deal with it. So on behalf of Allie, I wanted to thank everyone for participating in today's webinar. We hope that you found this useful, and have a great day.